Hello, everyone. Welcome back to the 2024 Hot Topics in Environmental Law Summer Lecture Series. I'm Jenny Rushlow, Dean of the Maverick Lloyd School for the Environment, Faculty Director of the Environmental Law Center, and Professor of Law here at Vermont Law and Graduate School. And we're very glad to have you here at the presentation today. Each of our talks is worth one Vermont CLE credit. So if you'd like to claim those credits as an attorney, you just need to keep track of those for your records. And we'll have time for questions and answers at the end of the presentation. But if you're watching on the VLGS YouTube site, you can enter your questions in the chat space at any point during the talk, and we will collect them and save them for the end and get through as many as we can. Today, we're very pleased to welcome as our speaker, Sean Donahue. Sean is a partner at Donahue, Goldberg, and Herzog, where his practice is focused on appellate litigation, with a focus on complex environmental and administrative law cases in federal and state appellate courts. Sean is a graduate of the University of Chicago Law School and afterwards served as law clerk to the then DC Circuit Judge Ruth Bader Ginsburg, and then later in the Supreme Court to Justice John Paul Stevens. After entering legal practice at the law firm Jenner and Block, Sean spent 4 years at the appellate section of the Department of Justice's Environmental and Natural Resources Division. He established his own practice in 2002, and since then has represented environmental and public health organizations as parties in many major environmental and clean energy cases before the U.S. Supreme Court and the Federal Courts of Appeals. He has taught courses in environmental law, climate change law, civil procedure, constitutional law, and other subjects at Iowa College of Law, Washington and Lee University School of Law, Georgetown University Law Center, and Stanford Law School. And we've been very fortunate that Sean has joined us in previous summers at VLGS to teach the course Environmental Appeals. Today, his talk is titled The Stability of Environmental Precedent After the Supreme Court's 2023-2024 Term. Please join me in welcoming Sean Donahue.
Thank you very much, Dean Rushlow, and it's delightful to be with you all virtually. I would rather be in South Royalton right now, but this will certainly do. The topic of this, the name of this topic is a little bit tricky since we're not quite after the 2023-2024 term. And the decisions that I think are most relevant to the topic remain to be issued. And they may come as early as Thursday, and they will certainly come in the next couple weeks. But I think it's still possible to describe sort of what seems to be going on broadly in the field, and then talk about sort of what's at stake in these decisions and how they, sort of what to look for when they come out very imminently. So I should note that I'm not asserting that instability that I will describe is limited to environmental law at all. It's certainly, there's a lot of ferment and change and uncertainty across multiple areas. Certainly true most, sort of prominently in the law of sort of reproductive rights, but certainly lots of other areas of constitutional law and administrative law. But the ferment is extremely pronounced for environmental law, in part because at least federal environmental law depends quite heavily on administrative agencies to implement it and make it effective. And since federal environmental law and EPA regulation of economic activity, and perhaps especially regulation of greenhouse gas emissions, are near the very center of the sort of counter-revolutionary tinged movement to change the law to so-called roll back the administrative state, to shift power from administrative agencies to judges and courts. So it's fair to focus on this, I think, as a environmental law challenge. As everyone knows, 2 years ago, the court took a big step in sort of refashioning federal administrative law with particular reference to climate regulation by EPA when it issued the West Virginia versus EPA decision that held that EPA's effort to limit greenhouse gas emissions from power plants, the Obama administration's Clean Power Plan, violated the major questions doctrine, which the court announced as a thing in that decision, though it insisted that the major questions doctrine had roots in many prior decisions. The major questions doctrine, I gave one of these talks a few days after it came out, and I made some sort of joke about how every big law firm that represents power plants and others in Washington, D.C. would create a sort of macro in their computers to like insert major questions arguments in almost every case challenging regulations. And I can report with no joy that has really happened. Major questions arguments are made all the time. What the agency is doing is too big. It's too, there's not sufficiently pointed statutory authority. We see that particularly on climate, but on a whole bunch of other areas as well. I think it's a little early to really gauge the importance of it, but it's clearly a big deal for agencies who are changing the way they write regulations, trying to focus more on text, perhaps scale down some things they would have tried before, emphasize more that the new regulation is in line with what came before. And I would say the other thing about that doctrine is that it may be influencing decisions even when it's not the basis of the judicial decision, as a kind of background sort of quasi-constitutional avoidance principle that, if we read the agency's authority broadly, that would implicate the major questions doctrine. So a big deal still to be determined. We know we had the next term, another indication of this ongoing ferment and sort of one might say backsliding or cracking of what had been somewhat stable understandings of law when the court decided the Sackett decision and read the Clean Water Act narrowly to exclude a quite large portion of the nation's wetlands from the scope of EPA's regulatory authority. A decision that didn't rely on major questions as such, but relied on adjacent, to make a bad pun, sort of judicial interpretive principles about federalism and private property, and sort of the desire to lower burdens on regulated parties, a sort of attitude of skepticism about regulation and lack of enthusiasm about the claimed benefits of federal environmental protection. That's one of the things that really stands out about the lead opinion in Sackett. So that's my case, that this sort of ferment and instability has been ongoing for a while and has already resulted in some big changes. I want to talk now about the cases that I think from this term may continue that in some really important ways. As every lawyer and law student knows, I think the court is poised to issue decisions in two cases that are basically the same case in two different versions, Loper Bright and Relentless. which are cases in which the court is asked to reconsider and overturn the doctrine of Chevron versus NRDC, which held that reviewing courts should defer to agencies' reasonable interpretations of ambiguous statutory language. And that those decisions, will be coming out in the next couple of weeks, and will apply, will or may, significantly affect the sort of basic ground rules of federal environmental law and regulation. The second case is less famous, and I would say less important, but still really important, and a really good sort of emblem of what one might mean by instability in environmental law. And that case is called Corner Post, and it is a case in which the question is whether a party can challenge an old Federal Reserve regulation relating to fees charged by companies that service or debit cards. And the question is whether the particular party Corner Post's challenge to regulations comes too late and is barred by the statute of limitations. That case is governed by the general statute of limitations for suits against the government, which is 6 years. That's 28 USC 2401. And that statute applies pretty broadly to all agency actions under the Administrative Procedure Act, where there's no more specific limitations period. So that's going to cover a lot of actions of interest to environmental and natural resources folks. It's not going to apply to like the Clean Air Act, which has a very specific requirement that anyone sue to challenge a regulation within 60 days of the day the regulation is published, or you lose your right to challenge it. But there are many other like public lands regulations and other environmental regulations that will be governed by the court's resolution of this question. The petitioners and Corner Posts have a simple argument. The statute of limitations says every civil action commenced against the United States shall be barred unless the complaint is filed within 6 years after the right of action first accrues. And the Corner Post folks' argument is our organization did not exist when this regulation was issued. I can't remember exactly how many years ago, but it was like, something like 15 or something. It was way above 6 years. But they say we didn't exist then, so our right of action to challenge this banking regulation could not have accrued. We didn't exist, and so we get to file within 6 years of when we were first injured by the rule. The question there is, and the government is very assiduously saying this would basically set the statute of limitations at naught, because anyone could create a new organization, a new trade association, a new company, and challenge a very old regulation, years after the statute of limitations, the 6-year statute had expired. And a sort of flavor of the nightmare vision for the folks who are worried about Corner Post is seen in the fact that parties actually did, like big trade groups did challenge this banking regulation in the District of Columbia courts, in the federal courts in DC. And the DC Circuit ended up upholding the regulation, saying it was a reasonable exercise of the Federal Reserve's power. But now this new entity has sued in the District of North Dakota, raising quite similar challenges to those that had been rejected long before in the DC Circuit. But they are basically saying that statute of limitations doesn't bar us, and we get a new shot. And so what the government is claiming is this would open up sort of endless challenges to old regulations. When you combine that possibility with these new doctrines like major questions and possibly elimination of Chevron deference, you can kind of envision a world in which the gates are wide open to challenging a lot of things that have been considered settled. And not only to challenging them, but challenging them in venues that are more congenial, where there are more conservative judges. Probably many folks have seen reference to the debate over single judge districts, where there's one, what judge you're going to get in a particular division within a district. And so you can kind of not just pick your forum, but pick your judge. Even if you can't pick your judge, obviously there is a huge difference between challenging an administrative rule in the Eighth Circuit, which has one Democratic appointee, and the First Circuit, which I believe right now, at least among active service judges, has 0 Republican appointees. So that's another aspect of this. So that's kind of why Corner Post, although not an environmental case, and about this sort of obscure statute of limitations, is actually, I think, properly viewed as potentially an important source of instability. I'll just briefly mention another doctrinal current that has the potential to be as important as any, maybe more, and that is the non-delegation doctrine, the idea that the Constitution forbids Congress from delegating in excessively broad terms power to agencies. And that's a doctrine that really has seldom ever been relied on by the Supreme Court, and not since the New Deal era. So the current court is considering a petition in a case from the Sixth Circuit called All States. It has relisted that cert petition multiple times. And that is a challenge to the Occupational Safety and Health Administration's basic workplace safety statute, on the ground that it is too open-ended. It doesn't confine what OSHA can do in crafting regulations on workplace safety. And that if the court, and there are indications that a majority of the current court believes the non-delegation doctrine should be revived and strengthened. If the court were to go there in All States or another case, that would be huge, because there's sort of nothing Congress can do with respect to at least certain kinds of problems. So that's big. The other thing is that if the non-delegation doctrine has life, it can really influence how courts interpret statutes, and agencies will want to avoid saying things like, we have broad authority to craft regulations under this open-ended statutory language. That is maybe good for agencies' statutory authority, but you might be walking into a finding of unconstitutionality. So that's something to watch. I want to talk for a bit about the consequences of overruling Chevron if the court does that in Loper Bright /Relentless. That going forward, that could be expected to make life more difficult for administrative agencies. The court might adopt a rule that the agency's interpretation will only survive if the court agrees that it is the best reading of the statute. And of course, as the environmental law students in the audience will be painfully familiar. A lot of environmental statutes are very complex and include a lot of difficult language. And the idea that a court and an agency will agree on what's the best interpretation, seems ambitious. So the likelihood of courts striking down rules seems like it would tend to go up. Again, a lot will depend on whether the court sort of mitigates its holding by saying, and there's some reason to think that some of the justices sort of toward the middle, like Kavanaugh, Barrett, and Roberts, may say things like this. If the court says, we're getting rid of Chevron, but we emphasize that courts should defer to agencies' specialized expertise about things like identifying whether a drug is safe and effective, or whether particular control technology is the best for controlling a pollutant cost effectively, et cetera. So that would provide a basis for agencies in some important circumstances to say, well, Chevron's dead, but we still get deference. There are a lot of ways in which how disruptive the decision will turn on what the court says, as one would think. And this is a case in which the court is likely to say a great deal. The six conservatives are not on the same page on everything, and this particular question is one in which they've written fairly disparate things, and so you may get a wide variety of opinions with a lot of thoughts that have to be kind of cobbled together and collated to figure out what's going on. One can see how even the process of trying to figure out what's going on while deciding actual cases is itself likely to be pretty disruptive, or at least labor intensive for administrative lawyers, agency counsel, et cetera, and district and court of appeals judges. So one real concern for my environmental clients and me is that a decision overturning Chevron will be interpreted as meaning that decisions that were decided under the sort of deference prong of the Chevron test. Chevron said if the statute's clear, you got to enforce the statute. If the statute's ambiguous, the question is whether the agency's reading is reasonable. When you have judicial decisions that say the statute's ambiguous, but the agency's reading is reasonable and therefore upheld, and Chevron is then struck down, what is the status of all those precedents? And that is an issue on which it was clear from oral argument that there was probably some different views among the conservatives, and Justice Barrett in particular was worried about that as a source of a lot of sort of flood of litigation type problem, that all these decisions would be overturned or at least revisited. And then, there was some suggestion from the petitioners that, oh, well, those are precedents, and maybe there won't be sort of open season. I think since all of this is about power and trying to curb administrative agencies' ability to prescribe rules that impinge on other people's activity, like factories, et cetera, one can expect that whatever the decision holds will be the basis for challenges to pre-existing law. I'll note just a couple of instances, important instances in Clean Air Act law, where there are decisions that were decided under Chevron Step 2, the reasonableness prong, that might be challenged. In the case Utility Air Regulatory Group, about a decade ago, the court upheld part of that decision, sort of castigated EPA and struck down a program. Another part of it upheld regulation of greenhouse gas emissions from factories in a way that EPA actually thought was important in comparison to the issue they lost on. And in that part of the decision, Justice Scalia said, reading the statute to apply to greenhouse gas emissions in this context is at least reasonable. Therefore, it survives under Chevron Step 2, and we don't need to decide whether the statute actually compels this result. And so that's an example of a decision that if the court says, there's no Chevron and it's got to be the best interpretation according to the judges, and the agency has to predict that or it's going to get reversed, that's one where at least parties could say, look, the Supreme Court has specifically said it hasn't decided whether the statute requires this. The reasonableness prong is now gone. We get to revisit that. There are others. There's the EME Homer City, really important Supreme Court decision that upheld EPA's program for controlling interstate air pollution, where an opinion by Justice Ginsburg and joined by the Chief Justice expressly relied on Chevron deference in upholding the program. And we already have seen indications that if Chevron is overruled, parties will say, well, that program is unlawful. It's not the best reading of the statute, even if it was reasonable and permissible under the old regime. So we're going to challenge it. So that's just two examples of myriad existing rules of law, previously promulgated regulations that could be subject to new challenges. Now I'll just briefly note a couple of other things about Loper Bright Relentless that are potentially indications of profound instability compared to what we thought environmental law was maybe a decade ago. Chevron was a unanimous decision. There were 3 justices who were recused, but it was 6-0, and there were lots of Supreme Court decisions in the decades that followed that were themselves unanimous and relied on Chevron. And it was a decision that initially conservatives lauded as giving the Reagan administration room to enact deregulatory rules, and as properly giving the executive branch an appropriate role in implementing statutes. And it only later did it become sort of controversial on the right as giving the administrative state and democratic presidencies who would come in and try to use authority relatively aggressively too much power. But what is remarkable now is that the court would actually consider outright overruling a decision like that has been relied on so many times by such lopsided majorities. And that is a sign that it appears that stare decisis itself is being re-examined. The petitioners in Loper Bright Relentless say, well, stare decisis shouldn't even really apply here, because this is really about meta rules of interpretation, not sort of specific rules of law. This is about sort of how judges go about their business, and judges should be able to change that in a more wide open common law way. So that's, a sign that we can, if they do it, there will be grounds for looking around and saying, well, what else is up for highly consequential re-examination that affects environmental law. And I think the non-delegation is just one example, but there are a lot of more specific rules that are sort of uniquely important to environmental law, maybe certain types of standing rules and all kinds of statutory precedents that could be re-examined. So sort of like, we've seen in some other areas of law, this might be seen even beyond the area of sort of review of agency statutory interpretation as another sign that litigants should sort of go for it. Parties that are challenging longstanding environmental precedents, should not be shy, because the court is really willing to consider things that would have seemed settled. We have in one of the pending challenges to Biden rules, we have at least one party that has thrown out that it intends to challenge Massachusetts versus EPA in the DC Circuit, which of course can't revisit Massachusetts, but the Supreme Court can, and so you need to kind of raise the issue, and we can expect an effort to do that. So it's really a sign that there's a lot of change coming, and a lot of it very challenging and daunting for environmental advocates. So I think I'll just briefly say that the potential consequences of a decision for the petitioners in corner post the statute of limitations case, I think I've kind of already given a sense of that at least in Administrative Procedure Act rulemaking challenges, there would be a greater ability to reopen past rules that everybody thought were sort of beyond the reach of challenge by using newly formed entities who can avoid the 6-year statute of limitations. That, as I noted, will not apply across the whole realm of environmental law, and a lot of the most important statutes do have their own limitations period, like the Clean Air Act's 60-day requirement. But the APA is a broadly applicable. So that too would be consequential and would sort of work in synergy with the broader substantive bases for challenging decisions of administrative agencies. And then I mentioned already the venue issue, that with a judiciary that seems more polarized, where there are judges who have very much openly embraced the critique of administrative agencies that one would have seen more in the Heritage Foundation and maybe some Federalist Society brown bag talks 10 or 15 years ago. You now have entire courts of appeals that are sort of dedicated to those principles or strongly believe in them. The Fifth Circuit comes to mind. And so the question of where challenges are to be heard is just dramatically more important now than it would have been before, when it was like, yeah, there were some somewhat more conservative or liberal courts of appeals, but you could still get different panels on each of them, and it wasn't that certain, and maybe you didn't want to look like you were forum shopping, and maybe you cared more about the actual convenience and proximity than matters now. But now the ability to get to a friendly court and then go big on attacking long-standing administrative law doctrines and precedents is just that's just a central feature of practice in this area now, where you see particularly the red state attorneys general suing, including outside their own circuit, because they want to be in the Fifth Circuit or the 11th Circuit or whatever, and get a more favorable forum. Okay, so I don't at all suggest that this. I think one way of interpreting this is that, oh, this is from the perspective of defenders of environmentalism and federal environmental law, ambitious climate rules, all that all of these judicial trends are like really negative, and so maybe you should just like give up or completely cede the federal law space and turn to state law only, which certainly has some merit as an idea that there are state systems that are very, very different in their how things will play out. But I don't think that is the right response at all. I think there are ways to continue to successfully defend meaningful action on environmental protection and on climate. We really don't have time to like wait and see how all this shakes out. Wait a decade or two and then try again. And I think the court itself it's not predetermined how far it's going to go with some of these things. So, for example, we will see, like in the West Virginia context, EPA went back and just a few weeks ago came out with a new power plant rule that relies on a more traditional paradigm of sort of regulating the sources themselves and relying on pollution control equipment. That's carbon capture and sequestration primarily in this context. And that is being challenged on multiple grounds, including, again, major questions. But maybe the court will say, no, look, I mean, EPA actually kind of listened to us, and we may think this is bad policy, but that is not our job. I think it's still possible that the court will say that. And I think it will be more likely to say that the more people are paying attention and calling the court out when it seems to be acting on sort of unmediated hostility to administrative action, to environmental lawmaking, to democratic initiatives. I think all of that. I don't think the court is kind of unaware of public criticism. And criticism from their peers on lower courts and the academy, et cetera. So I think it's worth fighting, and it's not at all predetermined where this is all going to land. With reference to Chevron in particular, as I think I mentioned, there are a lot of ways in which the court will likely kind of hedge if it does overrule. And we'll probably will say judicial respect for agency's decision should still be accorded where Congress clearly wanted the agency to rely on facts that it found about whatever the drug that's being, the application is being approved, and the agency has special expertise that the courts don't have, or where Congress used language like appropriable and some other broad terms that seem to be calling upon the agency in particular to exercise discretion. Justice Kavanaugh in particular has said that is an occasion where review should be more like the deferential, arbitrary, and capricious review than sort of a best reading type statutory interpretation. I mentioned as well, when the agency can say we've read the statute this way since the beginning, since shortly after it was enacted. It will probably help if Congress has revisited and amended the statute without changing the agency interpretation. I think many of those kind of moves will continue to be in play and will mean that agencies can win some cases without Chevron. And of course, there are a lot of our environmental statutes are written pretty favorably to the regulators. They are trying to achieve objectives. They are pretty adamant in their no discharge, whatever the goal is. And so sometimes emphasizing how favorable the text is can be a winner. There is a concern about the courts combining sort of emphases on textualism and taking away agencies' ability to elaborate upon or spin statutory language on the one hand, while also using doctrines like major questions, which are sort of can be seen as kind of anti-textual. They're kind of like, even though maybe the statute could be read this way or is looks like it means this, it can't mean that because of the consequences. So that's another thing that the court needs to be sort of called out on when it seems to not be consistent. Okay, I'm excited to hear questions. I'm going to just say a couple of things further about sort of the general thesis that we're in this period of sort of instability, unprecedented in the era of modern environmental law, which we might say is about 50 or 60 years. Beyond any one of these doctrinal shifts, there's just a general vibe or atmosphere that a lot of this stuff is being revisited, particularly among the most conservative, whatever, quarter or third of the federal judiciary right now. And that is just something that's going to continue to play out. And there'll be a debate about how far it should go, where good lawyering will be a key part of it. Politics and elections will be a key part of it. What I'm trying to urge is that for all the sort of what I might see as troubling developments that I've been describing, this is also a really exciting time. There is a reconsideration, a returning to the roots, a debate about what the roots meant, and a sort of fight about how important these laws are, and Vermont Law and Graduate School students, faculty, alumni are really well positioned to participate in that debate, and I know many of you already are, and I encourage everybody to get in it without necessarily having the right answer to it. It's really important, and I think it will shape what our society looks like for a long time. Exciting time to be a student of the law, I would say. With that, I think I will turn back to Dean Marshlow and see if there are any questions.
Excellent. Thank you. Okay, so yes, for the audience, we do have some time for questions. And again, you can enter your questions in the chat space on YouTube, and we'll get through as many as we can. And to kick things off, referring back to the case that's putting Chevron in question, how much do you think this particular set of justices may factor judicial efficiency into the court's consideration? Because you mentioned that this could really open up the floodgates to reconsideration of a lot of past decisions.
Yeah, it's hard to say. I mean, I do think judicial efficiency and sort of administrability for lower courts is a value that probably all the justices would subscribe to. But what it means for this dispute is probably going to differ. Like at oral argument, Justice Gorsuch, who is the top antagonist of Chevron on the court, who called for it to be revisited when he was a mere 10th Circuit judge and has consistently said it's terrible. He said, lower courts have no idea what Chevron means anyway. And so, getting rid of it is really, only a benefit. It's just a source of, lots of sort of churn and uncertainty. I think there were other views. In fact, one of the theories, and Professor Thomas Merrill at Columbia has written a whole book about Chevron that I would say is an interesting read. It sounds dry, but how this really important doctrine sort of emerged as it's sort of like how particular cases get famous and influential is a little bit random. Like Justice Stevens used to say, I didn't think that it was a big deal. I thought I was applying settled law on judicial review and statutory interpretation, and the sort of press and academy sort of treated Chevron as no big deal for a while. And then there was some things going on in the DC Circuit that sort of made it a little more, led to its being treated more like a new development. And one thing about Chevron is that everybody knew was it created this like apparently straightforward two-step process. First, does the statute directly speak to the question, the precise question at issue? If so, apply the statute. Second, if not, if the statute is ambiguous on the precise question before the court, then is the agency's decision reasonable? And then that can be a tricky question, but at least it's like a nice, format, a nice tight little approach for courts. And I think one reason Chevron became so widely cited is it had this perceived value of simplifying the process of statutory construction. So it's a little bit ironic that it's now being attacked as creating uncertainty. But I think I'll be really interested to see what Justices Barrett and the Chief Justice say because of that. I think they will want to say this isn't open season on everything, but how they get there remains to be seen.
Yep. Relatedly, after the set of justices has produced decisions like Dobbs, what is your reflection on how willing this current court is to overturn its own precedent of the U.S. Supreme Court as compared to a different composition of the bench in the past?
Yeah, I mean, so this is disputed, and there are people who say, look, if you look at the actual numbers of reversals of precedent, of overturning, they're not dramatically greater. There may have been other courts that did more. It's a little tricky because this court decides so many fewer cases, like a small fraction. I think it's probably it's about a third as many as some of the courts in the 70s, and it's about, like, when I clerked in the early 90s, it was probably around 92 cases in that. So it's like 40% reduction from that. So I think at least in some of these, the other thing is overturning a precedent about some arcane provision, and I don't mean to slight bankruptcy law because it's important, but some bankruptcy decision that's going to be pretty narrow, maybe important to one area of law, but it may not be sort of a sea change like overturning Roe versus Wade or Chevron. So I think you would want to wait to accord value to the magnitude of the precedent. And the fact that they were willing to go where, the Rehnquist court walked right up to overturning Roe and stared into the abyss and said no. And there were three sort of moderate judges who said, no, precedent's really important. This would be too violent a change or disruptive a change for our society. We're going to kind of scale it back a little bit, and I think that's where the Chief Justice wanted to go with Roe, and they didn't do that. I think Sackett too. It was a bold stroke. They adopted the approach that had not gotten a majority before. That has a very pronounced consequence, pretty undisputable. So in my view, these are pretty striking, and Chevron I think this would really, at least with some of the other ones, there was a very strong sort of counter trend jurisprudentially. There were arguments from the beginning that not only Roe, but earlier decisions on substantive due process and privacy were lacking in, constitutional textual basis and all that. There were dissents, obviously. There was a strong series of dissents on those issues, and so Chevron was unanimous, and it really so in that respect, the majority here now is like pretty confident, at least about some of these freighted issues, and they feel like they have a big majority, and they should use it to change the law in the way they think is right. So, but I'm sure every single time it's a a balancing test, and that they do think about blowback, and we're, the political blowback from the Dobbs decision is not over, and so it'll be interesting to see whether that affects how they. I don't think that overturning Chevron, will be at all comparable politically, but some of the particular things that may follow, I think, people are not on board for getting rid of, safety regulations in the workplace, et cetera. So it might not be quite as sort of visible, but there may be some blowback there too.
Yeah, in terms of the court's appetite for navigating blowback, it'll be really telling to see how the whatever the follow-on case to West Virginia v. EPA is with the new power plant regulations, how they respond to that, as you referenced, whether they take the opportunity to say, okay, you listened to what we had to say, and obviously the regulations you produced are very responsive to our opinion, or whether they just can't let it go.
Yeah. For ease of reference, I believe the follow-on to West Virginia versus EPA is called West Virginia versus EPA. So,
right.
That's a different docket number. So,
okay, thanks. Okay. I wondered if you could talk a little bit about the Hawaii youth climate case and what we might expect coming from the U.S. Supreme Court, since that's something a lot of environmentalists are wondering about.
Yeah. It would have to be a little bit, because I'm much less well informed about it. I know that these sort of common law actions under a whole bunch of different theories, federal and state, and in a lot of different state and federal courts, have been percolating. And so far, the court has really not shown great interest, with, you might say, one exception, which was the Juliana case, where the court didn't grant review, but it sent an absolutely withering message to the Ninth Circuit to kind of, terminate this case. That, of course, was a little different. It wasn't state common law theories. So I think it's really important, particularly if we're getting all these shifts in federal environmental law, that there be a space for states to experiment. And I know Vermont has just enacted, one of the most important experiments with a statute that imposes liability for climate related expenditures on companies that are responsible for more of the emissions than many others. That's an example. But beyond that, I know, we will see whether the court, and the Vermont statute is another example, is this court willing to accept the sort of discomfort of allowing these kinds of experiments to proceed in basically blue states, even though the majority probably sees the policies as, terrible policy and offensive and all that, or are they going to kind of stop them? And I think, that one of the arguments about the virtues of federalism is that it sort of allows different states not only to experiment and maybe find things that are effective or not effective, but also to kind of give different political constituencies the room to do what they want to do. And I think, if they sort of shut the door on common law approaches or ambitious state statutes like Vermont's and what New York is also contemplating, I think that will, probably turn up the temperature even more on sort of just a sense that the court is blocking progress on climate in a way that's, you know, really problematic. But we shall see.
Okay, thank you very much. And for folks that are interested in this issue, we are planning to have an episode on our podcast, Hothouse Earth, after the conclusion of this session of the Supreme Court, where we can revisit the final outcomes of some of these cases. But we are out of time for today, so we'll wrap up this talk. Thank you again, Sean, for your wonderful presentation, sharing your expertise with us. And thank you to our viewers for joining us today. Our next talk will be online on Thursday of this week at 12 o'clock Eastern. Have a good day, everybody.
Thank you. Take care.